Jesse Lozano, also represented by Attorney Ruane.
Yes, James Ruane for Mr. Lozano, who is here and prepared to answer any questions that the board may have. I can supply that there have been no changes to his arrest or conviction history since the filing of our application, nor do we have any supplemental materials to provide to the court today. I would indicate to the board that this was an incident of, I guess you would call it sexting, and not actual contact with the person physically. But I'll turn it over to Mr. Lozano, who is here and can address the specifics of the case, as well as any question and answer any questions you may have.
Thank you. Sir, can you please state your name for the record?
Of course, my name is Jesse Lozano.
Thank you. At this time, you may explain to the board why you believe you are suitable for an absolute pardon.
Thank you, sir. First, I'd like to thank the board for granting me a hearing today. I believe I deserve a pardon because in the 6 years since my conviction, I've worked hard to understand the reasons behind my criminal behavior, to turn my life around, and to get to a place where I would never even consider making the same terrible decisions that led to my arrest in 2017. Back then, I was stuck in a deep depression. I had just moved to New York. I was living in a friend's basement. I had very little work and almost no money in the bank. Back then, I didn't have the emotional intelligence to understand what I was feeling, nor did I have the maturity to deal with it, which is why I was desperate for validation, even from a minor. Now, after going to 2 years of court-mandated therapy, plus the private therapy I sought on my own, I understand that my emotional stability comes not only from a job or a savings account, but from serving my community, as well as having a support system of family and friends who care about me. This is why I've reorganized my life so that I can volunteer at a food bank on a weekly basis and visit my family in Texas at least once every 2 months. In addition, I am proud to say that I now make a livable wage as a freelance musician. Now that I've gone to therapy and turned my life around, I truly feel like I'm a productive member of society, and I can say without a doubt in my mind that I will never act inappropriately with a minor ever again. But what I cannot do is take away the damage I caused to the victim and to the victim's family back in 2017. I preyed on the victim when she was in high school, one of the toughest periods of a person's life. I can't imagine how much harder I must have made it by manipulating her, by taking advantage of her, and by putting her in a position where she had to deal with the police and an attorney in a criminal investigation. And for that, I'm truly, truly sorry. I can't imagine the fear I must have caused the victim's parents. To go through your child's phone and discover text messages from an older man is a nightmare I hope I never have to experience. And the thought that I put them through that still makes me sick to my stomach. Then, of course, there are my parents who raised me to be a much better man than the one I was back in 2017. Some of the deepest shame I feel is due to the thought of how hard they've worked their entire lives to give me the opportunities I've had, and how I squandered them all with just a few bad decisions in just a few short weeks. I wish I could take back the damage I've caused, and if there's anything I could do to ease the suffering of the victim and the victim's family, I would do it in a heartbeat. Unfortunately, I can't erase the past, but I know that I've grown, I know that I'll continue to grow, and I know that I will always strive to be the best son, friend, employee, and community member that I can be. Thank you for your time, and I'd be happy to answer any questions that the board may have.
Thank you, Mr. Lozano. I'll turn it over to my colleagues. I just had one quick question. You're aware there's a protective order in place until 2028?
Yes, ma'am, I'm aware.
Have you attempted to have that protective order modified or dismissed?
I'm sorry, could you repeat the question?
Have you attempted to go back to court to address that protective order?
I have not gone back to court, no.
Okay. Mr. Pohl.
Thank you, Madam Chair. Good morning, Mr. Lozano.
Good morning, sir.
So I read this case, and we're dealing with a matter of inappropriate texting with a student.
Yes, sir.
You were 25 at the time?
Yes, sir, I was 25.
And the student was 15?
Yes.
Did you ever have sexual contact with the student?
No, sir, I did not.
So it's concerning. You know, Own self-disclosure, my husband's a music teacher, a high school music teacher. And I know how much his kids deal with on a daily basis. So it's you know, especially in the music department, this is, you know, it's a place where students that have different challenges wind up. So I appreciate your remarks. I appreciate how much you've reflected on what happened in this particular case. And I also heard what you had to say about how you feel about that today, and how it's not something that you have, you know, taken for granted. I when it comes, I noticed that there were good letters in here from your mom, your friend, and a therapist that you see on an ongoing basis.
Yes, sir.
And the therapist really addressed what you've dealt with in treatment and such. So I'm not going into that because we're live here, but an offense like this certainly is something where we need to do ongoing types of things. So I can appreciate the fact that you're still in therapy. One of the things that you talked about in your application, and I believe this morning, was part of the reason why you want this pardon is for professional reasons. Can you elaborate on that a little bit?
Yes, sir. Because I'm a freelance musician, different jobs last different amounts of time. Sometimes they're a week, or in the case of the current job, I have 8 months, and it's a recurring job. But part of my career is looking for new jobs constantly, and I've been lucky over the past 6 years to be steadily employed. But the prospect of having to constantly apply to new jobs is nerve-wracking when I have conviction on my record.
And I can totally understand that. You're currently in Oregon,
Yes, sir.
and is that where you plan to stay?
It depends on how the job turns out. This is my 3rd season with the theater, and if they keep hiring me, I'll keep going back. And I plan, if I do 5 seasons there, that will mean enough of my life is there to transplant myself and make that my home.
And if you weren't in Oregon, where would you be living?
I have an apartment in New York. I'm not there very much, as I spend most of the year in Oregon.
So New York City.
Yes, sir, Manhattan.
Okay. So I pretty much have everything that I need. Thanks, Madam Chair.
Thank you, Mr. Pohl. Ms. Chance?
So I too, Mr. Lozana, read all your support letters, and specifically the letter from your therapist where it was talking about what you worked on. And I know they were only inappropriate text messages. I cannot imagine what they did to the 15-year-old. You were 25 years old. You completed your probation in January of 2020. But I would like to see you continue to work some more on some of those things that you have been addressing with your therapist. And I just wish you the best of luck.
Thank you, Ms. Chance. Mr. Lozano, did you move to New York after this incident? After your arrest?
It was almost around the same time. I believe I moved to New York immediately before I got called into the police station for questioning. It was almost within the same week.
Did you move as a result of this offense?
No, ma'am. I was living in Westchester. So I was already very near the city, and I just wanted to live in my own apartment.
Okay, so we do have input from the Office of Victim Services in this matter. We'll turn it over to them. Ms. Vasquez, thank you for joining us.
Thank you, Madam Chair and board members. I do have a victim who is logged on. And this is your opportunity to please unmute yourself and address the board members. Thank you.
Hello, thank you for hearing me out. I just wanted to bring kind of the lasting effects that this has had on me. I was in a very vulnerable part of my life, 15 years old, very depressed, going through a lot of things. And Jesse recognized that, preyed on that, and manipulated that. And the effect of that is that a vulnerable person was made even more vulnerable. I've had a lot of difficulty trusting people since this, as this was a person not only who was an adult, but someone who was in a place of authority, and someone who I really respected, and working in the field that I was interested in and still work in this day, theater. I ended up facing a lot of backlash from my community and from my family as well. Let's see. There was letters and texts, yes, but there was also in those texts, I was supposed to meet him in his new apartment in New York. So there was an intention to take this beyond just text messaging, sexual in nature as they were. Also, this was an expedited loss of childhood that I had no control over. I trusted this person, and in a very vulnerable part of my childhood was ripped out of that. And I just wanted to submit my experience. So thank you for listening.
Thank you very much for your input. Okay. All right, discussion, Ms. Chance.
So as I originally said, I would like to see Mr. Lozano continue to work on some of the issues that he started working on with his therapist. And it was a little unnerving to know that, he was making arrangements to continue when he got his apartment in New York. So that was concerning. And he has a very long-standing criminal protective order. I really think he needs to spend some more time working on himself. So I would not be in favor today, Madam Chair.
Mr. Pohl. Thank you, Ms. Chance.
Thank you, Madam Chairman. I had a question. I fully understand and respect the victim's statement in this matter. I don't know that I heard if the victim was opposed or just wanted to make the board aware of her feelings and leave it to the board to make a decision. I wasn't sure.
Yeah, there was no clear, statement about being in favor or opposed.
Right.
I am opposed. Thank you.
Thank you.
Thank you.
So, I appreciate that, and as I started out with my questioning with Mr. Lozano, I understand the music department a little bit and how somebody vulnerable like this victim would be in the music department and actually look to be supported rather than what happened here.
Mhm.
And so Mr. Lozano has done work. He is with a therapist still. He's in a different state. He is not teaching. He's I don't know what additional things we would have Mr. Lozano do in order to gain a stance where his life wouldn't be further impacted by this on his record.
Mhm.
Fully understanding the feelings, thoughts, and impact on the victim in this case.
Mhm.
So I'd be interested in what the chair has to say here.
So for me, I do hear a lot of insight. I am happy that Mr. Lozano is continuously working on himself, but I think that perhaps maybe just time, some more time, would be necessary in this case. Uh, Certainly wouldn't hurt for him to continue to work on himself, especially given the fact that he's going to continue to work with people and possibly youth. We don't know. There is the standing protective order that I started with, that we never like to erase. It's imposed for a reason, and this is not a lifetime protective order. So I'm going to make a motion in the matter of Jesse Lozano. I'll make a motion to deny an absolute pardon. Ms. Chance,
Aye.
Mr. Pohl,
Aye.
my vote is aye for the following reasons: the impact to the victim and/or the victim's family. The serious nature of your offense would be diminished by expungement of your criminal history, and you have an active standing criminal protective order. Wish you the best, sir. Keep working on yourself. Thank you all for your input.
Next, we have
What a roach. You just, Connecticut has got issues. Let's keep in mind that he's a teacher. He's a teacher in a private school, and he is sexting his student. They catch him, and they give him a fully suspended sentence. He did not spend one night incarcerated. He was a teacher. This isn't like some whatever, like in his basement on those chat things. He's a teacher. She's his student. He's grooming her. This is a predator. This is the most dangerous. But they gave him a plea deal where he did not spend one night locked up. Are you kidding me? Like To Catch a Predator, now you actually see where it's just some creep on a computer falls for the decoy, goes to the house, and they get actually prison time now and have to register. And here where you have an actual teacher with everything on the record, and they gave him a plea deal with no prison time, and the insult to injury is he doesn't even need to register, because the plea deal they gave him was risk of injury, nothing else. Why? And then he has the audacity, and why not? He's already gotten away with it. Why not? To show up, what is it, just 6 years since his conviction date, and ask to get his record clean, expunged. Survivor, I salute you. I love that she got up here and set the record straight. That is taking the power back. That is saying, no, not on my watch, sir. As a teacher, you have the opportunity to change your student's life forever. in the most wonderful ways. I think most of us have that teacher that has done that for us at some point in our lives. And as a teacher, you also have the ability to change that student's life forever for the worst. And for it to happen and just get a slap on the wrist where you really have nothing in place to protect future children except the idea that he has something on his record, doesn't have to register, didn't have to spend jail time, 2 years of court order therapy, and I am changed. That was it. And then you get to the last wall of defense, and it's the pardon board. And thank goodness they denied. I mean, we have seen some stuff that has gotten me concerned, and we'll go over the bios of those 3 pardon board members if you've been curious to learn about them. Thank goodness that her parents looked through her phone, right? And saw those messages. You know, one of the board members, who was it, Mike, he's he says, my husband's teaches music, and he this is scary. It's like this is so scary that to think that you have a predator in sheep's clothing who positioned himself so that he would be surrounded by sheep, a wolf in sheep's clothing. And what is it that he says, his reason for it, his little speech? I was stuck in a deep depression. I was desperate for validation. I was poor, and I was in, like, yeah, man, you're a music teacher. This is what you signed up for. You're not going to be, floating in the money, bro. If that's something that sets you off, then I think that's even in itself telling. If you go into music, it's because you love music. You're going to be a music teacher, it's because you love teaching music. You don't have the expectations of being comfortable financially. I have a brother that makes a living in music. He struggles every single month, but he is happy because he loves what he does. He's darn good at it too. He is real talented. Now let's go to our little prince here. Former Greenwich teacher sent inappropriate texts of 15-year-old girl. This is like, sometimes headlines are so ridiculous. Let's fix it. Teacher grooms 15-year-old student. Former drama teacher at an unnamed private school will face felony charge of risk of injury to a minor. And why is it just that charge? I don't know. Why is it not something else? I don't know. Following the decision of Superior Court, Jesse, 25 of Brooklyn, was arrested on a warrant. He is accused of allegedly exchanging inappropriate texts of sexual explicit nature with his former student, a 15-year-old girl. And she was his student at the time, right? They're saying former because he's got busted. The complaint against him was lodged on March 27th of this year, according to police. He sought to enter a court-ordered. This is what he asked for, but why wouldn't he, right? I want a court-order accelerated rehabilitation program, but he was denied by the judge. Thank you, Judge. His attorney argued that Jesse was trying to discuss a frank play with the student. That's what his attorney says. Frank play. What? Okay. Well, yeah. What does it even mean? Which the attorney said his client should not have done. Oh, it's just a frank play. They make up words now. And it made the news.
New this morning, a former Greenwich teacher private school teacher has been sentenced to 2 years probation. This after sending inappropriate text messages to a 15-year-old student. Jesse Lozano of New York City pled guilty this week to a charge of felony risk of injury to a minor. Police say Lozano tried to lure a female student from his school to his home in Brooklyn.
Yep, that's it. But hey, I mean, no prison time, no registry for you. And then imagine if he had gotten the pardon, right? That would mean that his record would have been expunged. That would mean that he could have gone back to teaching kids. You can't make this stuff up. And you just can't make it up. He was sentenced, right? 2 years probation. I can't get over this. 2 years probation. And thank you, Richard, for tying this information together. Miss Rose sent me this and said, you got to cover it, Mandu. And thank you, Miss Rose. And then all I do is send it to Richard and boom, I got everything lined up. It makes it so really easy for me to do this. And I'm able to ship out all these uploads because of the system that I have. I have many of you who send me here, and it's not an easy thing to send a hearing, right? A good one, like you know what will work. If I were to have people sending me hearings that were just like, no, I just spent like half an hour looking at it, and it's just not that, it wouldn't work. But you know what to send, and then Richard, I have it all here. It's amazing. Let's see another link, Richard share here. I always need to look things over and to make sure, just sure there's not like an address in there. Although Richard does that too. Now okay, so ex-teacher denied probation program. A former teacher at Connecticut private school who is accused of sending inappropriate text messages will not be allowed to participate in a program that would remove the arrest from his record. What he was asking for would have even removed it from his record. Wow. It's so creepy. I don't know why they only charge it felony risk. Why is that all they're allowed to charge? The attorney says the texts were out of character. He says he was trying to explain some of the plays discussed in class at the Greenwich School. Look at the attorney still denying things. He was just trying to explain some of the plays that they discuss in class. Prosecutors say that he planned to meet the girl at his home, but never did. So there you have it, right? There you have it. You might not believe it if you didn't see it. So here, let's go look over this right before I forget. So we have Jennifer, who is, I guess, the most senior person here. She's the chairperson. So Jennifer was appointed to Connecticut Board of Pardons and Paroles, full-time board member since 2014. So she's been there a long time, 10 years. She was appointed chairperson only recently in April 23. Her experience and education prepared her for the initial appointment to the Board of Pardons and Paroles. She holds a BA in sociology from Central Connecticut, a master's in criminal justice. And she began her career in social services as a residential monitor and treatment social worker with the Alternative Incarceration Center. She's highly qualified. And was responsible for the direct supervision of approximately 40 residents who were on pretrial, probationary, or parole status, receiving more. She also worked as an investigative social worker and social work supervisor with the Department of Children and Family. Wow. So she's seen a lot. Her primary focus was the protection of Connecticut's children. So let's remember this. Because these are the same board members that we have hearings for when we don't see them on the screen. So we just have to remember, Jennifer, if they ever make something that seems strange about protecting our children, we'll have to ask ourselves, how is that possible? She was responsible for providing families with the necessary services and programs to maintain their family unit, provide tools for successful reunification of families when possible. She was the first to respond to allegations of child abuse and neglect, and ultimately made the discrimination whether a child was at risk or harm. That is so heavy. Can you imagine having that job? I could not. I would not be able to sleep at night having that job. Not only to be the first one on the ground to investigate it, to see that trauma, but then to have the decision riding on you. And if you're wrong, oh my gosh. Mike. So Mike is the man who is married to the music teacher. So he was appointed to the Connecticut Board of Pardons and Paroles full-time member in May 2019. Prior to his appointment to the board as a certified teacher, he taught 8th grade. Right, okay, I read this before. In United States history. So he was a history teacher. Married to a music teacher. He was appointed in 1986 to Connecticut Alcohol and Drug Abuse Commission due to his experience and knowledge in the prevention and treatment of alcohol. So he's kind of like a Mr. Mirabella, that kind of guy. He was the executive director of Pathfinder Association, where he began his own personal recovery. Yeah, where he's like a Keith Jones. Keith Jones is personal recovery. I don't think Mr. Mirabella still drinks. He's talked about that. But he's like a Keith Jones. Personal recovery of an addiction, 1984. For the past 35 years, Mr. Pohl has worked for many people seeking recovery. In most recent years, people recovering from opioid. Mr. Paul has been in justice and peace for the past 25 years. I mean, I like their bios. I really do. Then we have, was it Chance? Where is she? Joy Chance. So she's a full-time board member. Miss Chance, I know I've seen a lot in the comment section. She reminds of like Miss Jackson. She kind of does. Although Miss Jackson's more like Miss Jackson reminds me of like a Judge Judy, a little bit more tough. She was appointed to Connecticut Board of Pardons and Paroles full-time board member, then 16 years of supervisory experience evaluating parolees for appropriate placement. She most recently worked as a therapist with Connecticut, with the Connection Inc. She was counseled and assisted parolees in maintaining parole compliance. Why is my screen like, come on? It's just so weird. Whatever. And maintaining parole compliance. Prior to the position, Ms. Chance served as Director of Employment Education, training both staff parolees of Heart Association. Ms. Chance began her work in social services as a program supervisor at the Open Heart Association, was responsible for the direct supervision of approximately 50 residents, probation, pretrial status, as well as Department of Correction inmates who were receiving a variety of services and work release opportunities. So there you have it. We got some insight into the board, and we were able to see the board make a, I would say, excellent and quick decision. Thank you again, Ms. Rose and Mr. Richard, or Sir Richard. And with that, I'll let you go or move to the next hearing. I'm not sure.
Charge number 1, condition of release direction under subcategory of GPS. Your parole officer reported that on 1/13/23, you allowed your GPS to shut down from 1:51 a.m. until 9:50 a.m., making your whereabouts unknown for approximately 8 hours. Your actions violated your GPS agreement, which states I'm responsible to ensure that the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electrical outlet for at least 2 hours each day. Charge of program participation. Your PO reported that on 5/11/23, you were placed in the Chrysalis Center Transition Services Program. On 5/19/23, you read, signed, and acknowledged full understanding of the participation agreement. On 7/7/23 at 8:30 a.m., a female was found in your bedroom, unclothed. Multiple directions were given before she awoke. You failed to follow instructions as the agreement states, not have any visitors in the CTS apartments from 9 p.m. until 9 a.m. Under no circumstances are overnight guests allowed in transitional apartments. Participant understands if overnight guests are allowed, discharge will follow immediately. Charge number 2 under obey all laws, obedience to the law. Your parole officer reported that on 5/23/22, you registered your address with the Sex Offender Registry Unit as 26 Sisson Street in Apartment 7 in East Hartford, Connecticut. Sex Offender Registry Unit mailed you a 90-day verification letter on 11/4/22, which you failed to return. On 11/18/22, you were sent a notice of violation, which you failed to return. On 11/28/22, you were sent a final notice of violation, which you failed to return as well. You did not notify the registry until 2/9/23 of your address change. Subsequently, an arrest warrant was lodged due to your non-compliant status. You were arrested and charged under Connecticut General Statute 54-252, failure to register. On 3/11/23, you were issued a complaint ticket due to a verbal altercation with the assistant manager of your employment. The verbal altercation escalated to a physical altercation at Wings over West Hartford. Subsequently, you were charged under Connecticut General Statute creating a public disturbance 53A 181A. Charge under halfway house placement. Your parole officer reported that on 2/26/23, you were issued a community pass to work. You exited the halfway house at 2:56 p.m. GPS confirmed you failed to report directly to work, deviating in an unapproved vehicle to the north end of Hartford. You did not report to work until 4:30 p.m. Your actions placed you in direct violation of the halfway house agreement, which states I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. On 3/1/23, you were issued a community pass to work. You exited the halfway house at 1:56 p.m., deviated to Manchester and Wethersfield before reporting to work. You did not arrive to work until 5:03 p.m. Your actions place you in direct violation of the halfway house agreement, which states I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. Charge number 5 under problem sexual behavior. Your PO reported that on 7/7/23, a review of the contents of your cell phone revealed several sexually explicit videos and pictures involving you engaging in different sexually explicit acts with yourself and with other parties. The sexually explicit content was stored on your cell phone. This is in violation of your computer access agreement. You had multiple social media platforms, Facebook, WhatsApp, Instagram, TikTok, and Snapchat. Without the recommendation of CTPSB staff or this officer, you had pictures of unidentified minors without the approval of CTPSB or this officer. You failed to disclose the treatment in your existing sexual relationships. Your behaviors violate your course of treatment, placing you in direct violation of your treatment agreement number 15, 16, and 19. All right, so those are your charges. I do have evidence from the state. Exhibit A, Board of Pardons and Parole's conditions of parole, 2 of them. B, remand to actual custody. C is a notice of parole violation. D, parole violation report. E is a computer access agreement. F, parolee notification form. G, consent to undergo evaluation, treatment, supervision by special management unit. H, GPS agreement, parole and community services. I, offender misconduct. J, offender misconduct. K, open heart incident report. L, GPS event history. M, Chrysalis Center participation agreement. N, East Hartford police case incident report. O, TCI communications discharge letter. Or community, I'm not sure what that means. TCI comms discharge letter. P, the connection treatment agreement. Q, halfway house agreement. R, West Hartford Police Department case incident report. S, West Hartford police complaint ticket. T, sexually explicit digital images and videos. All right, and we do have an addendum from the state. Addendum number 1 reads that on 1/3/24, offender appeared at court. Offender was sentenced on failure to register sexual violence to 18 months jail. 1/3/24, offender appeared at court. He was sentenced failure to register sexual violence, 18 months jail. On 3/11/23, offender was charged and issued a complaint ticket for creating a public disturbance, ordered to pay a $103 complaint ticket. All right, so that's what I have from the state. I do not have a parole officer here to offer any additional evidence at this time. So is there anything you would like to say regarding the charges or counsel on your behalf?
Yes, thank you.
Yeah.
In regards to charge 1, release direction GPS, my client maintains that he was in the halfway house at the time. He was sleeping and the device did unhook itself. He was living at Open Hearth. And I would just note that there's no noted misconducts or violations from the halfway house for that date. I would also note that this one alleged violation took place approximately 6 months prior to my client being remanded. In addition, my client was issued a verbal intervention sanction, which was served successfully. In regards to charge 3, I would point out that the addendum is accurate, but I would also point out in regards to the March 11th of 23 complaint ticket that he did plead by way of just mailing it in. He did not actually appear in court. He just mailed in the ticket, and that charge is actually an infraction. In regards to charge 4, halfway house placement, my client maintains that he was issued a pass, that he typically takes public transportation, if you will, to and from work by way of Uber or Lyft. That his employment began at 5 p.m. And that he stopped to get food prior to entering his or beginning work. Exhibit J is a misconduct regarding this incident that indicates that my client was successfully served the sanction of an added 30 days on GPS. And that is speaking to the first paragraph regarding the February 26th. In regards to charge 5 under problem sexual behavior, I would just point out in regards to the conduct that's indicated here, that my client was involved in consensual relationships with adults, and that he was not accessing any type of pornography or child pornography by way of the internet, that all of the videos that were located on his phone were all ones that he was a participant in, and that he was were taken with consenting adults. Nothing further as to the charges.
All right, charge number 1, condition of release direction under GPS, and making a finding of violation based on evidence provided by the state, specifically the GPS monitoring agreement, as well as the document Exhibit I, the misconduct report. Charge number 2 of program participation, and making a finding of violation based on evidence provided by the state, specifically the documentation from Chrysalis Center Transitional Services Program, which describes the program regarding what the program was for and what it was going to do, and different things that you had to participate in that you signed, and also the report regarding the incident, Exhibit O, the discharge letter as well. Charge number 2, condition of obey all laws. So I am breaking this into 2 parts. The first part is the 52322 for the failure to register, which I am making a finding of violation on. You were pled guilty and you were sentenced to the 18 months for that failure to register charge. And the second, the 311, the infraction, I am making a no finding on that charge. It is an infraction. And you mailed it in, there was a fine. Charge number 4 of halfway house placement. I am making a finding of violation based on evidence provided by the state, specifically the halfway house agreement, and also the documents regarding the 226 and 31 incidents as well. And problem sexual behavior charges. Okay, regarding the 7723 incident, I am making a finding of violation based on evidence provided by the state, specifically the connection treatment agreement, and their specific numbers of the treatment agreement that I'm referencing there. I don't know if I'll be able to find it again here. Hold on. Number 15 and number 19 of the PSB treatment agreement.
One comment.
Oh, yeah, go ahead.
Neglected to me, sorry. Just in regards to that last portion.
Yeah.
Regarding the social media, there's just no indication, based on any of the evidence that he had any of those things on his phone.
Yeah, I was gonna, I separated them because I was going to go into the part 2 of that.
Okay.
I don't think there's, I agree with you. I don't think there's any evidence regarding the social media stuff. Hold on one second. Let me just refer to the discharge summary. All right, so I'm going to make a recommendation. I do recommend that your parole be revoked and that you're re-paroled on July 18th of 24, which is a 1-year sanction. And with conditions of no contact with the victim, JH, no contact with minors, this would be our updated condition, halfway house placement, mental health evaluation, problem sexual behavior treatment, which would also be an updated condition, and MOA. All right, so what's going to happen now is that I'm going to put your case in front of a panel of the board on February 15th, next week, okay? The board is going to make the final decision. The board can either accept my recommendation of the 1-year sanction for the July 18th of 24. They could put you out before that, okay? They can put you out as early as April 14th, I'm sorry. Or they could want you to have a longer sanction. If they want you to have a longer sanction, they have to give specific reasons why they want a longer sanction, and you would be brought back in front of them for another hearing. Okay?
All right.
Do you have any questions for me, sir? No?
Honestly, I just want to just go home. Like, I really don't want to be in jail no more. I was doing good. I made a mistake, but everything, I just want to just get this over with, because I don't really supposed to be in jail. Supposed to be like doing all this extra time. I was doing good for 2.5 years. I made a mistake, violating. I was doing good.
You were doing, I mean, it looks like you were doing good. As opposed to me saying, no, you're going to serve the rest of your 18 months in jail. I said, no, I'm actually going to give you a shot and put you out earlier than that and put a MOA condition on you. Okay.
So what does MOA mean? That's what I'm going to ask.
So MOA, all that means is that we have an agreement. BOPP has an agreement with DOC that if we recommend you be re-paroled before you finish your sentence, that they will look at your case and DOC will review your case and look at you for TF placement. Okay. So even though I'm recommending that 7/18 date, you probably won't be released exactly on that day, because DOC does have to do what they have to do to look at your case and review it for TS. Okay?
Yes.
All right. So this concludes the revocation hearing for DeMont Harper, number 389523. All right, you're all set, and you'll get something in writing next, I would probably say next month or the end of February with what the final decision is, okay?
All right, thank you.
Yep.
Okay, I'm not going to share an article, but I'm going to read you the research that Richard provided so you can just get context of what this man has done. And really what it seems to me is a continuation of Connecticut just saying, here's a little slap on the wrist. I mean, let's keep in mind, he's a sex offender. His tracking monitor just, went down for 8 hours. He's found breaking all the rules. And it's like, you'll get this little sanction, you get that sanction. And it's like coddling, in my opinion. Now, you might say, why are you so upset about this? It's that. It's not such a big deal. But here's what happened. In 2012, April 20th, he and two other men in school during school hours. Now, he was 16 at the time, but he was considered, out of the three men, the main bad guy, in quotes. They allegedly sexually assaulted a 15-year-old student during the day in high school. So she left the classroom. It was a substitute teacher. She said that the substitute teacher locked the classroom door. She couldn't get back in. The two boys took her into the men's bathroom and began the sexual assault. A third boy joined. The prosecutor, the state prosecutor, Vicky something, Melly Corey, said proving the girl's allegations that she was sexually assaulted was difficult. We did meet with the victim and her mother. We explained the difficulty of proof in this case. They agreed to the disposition, not happily, but they agreed, she said during the sentencing in Superior Court. And what was the sentencing? It was 3 years probation. Are you surprised? But wait, that's not all. So they pled to second-degree unlawful restraint and second-degree reckless endangerment, and they received a 6 months suspended sentence and 2 years probation. All three admitted to police that they had sexually contact with the 15-year-old girl, although their descriptions varied. The assault allegedly occurred at 2 p.m. in the boys' bathroom. So they claim that it was consensual. There is evidence that her friend, that she had told a friend that she had consensual sex with two of them, not in this occasion, but at other occasions. There's video footage of the two boys and her in the hallway at 2 p.m. And his defense attorney said the video recordings of the girl and the boys in the school hallway showed them horse playing around. They're just horse playing. And he believes that they were still, this is to quote the attorney, that what happened in the boys' bathroom was still horseplay. She claims that she was sexually assaulted by 3 men at 2 p.m. in her high school, supposed to be the safest, although we know it's not anymore. Like, schools don't seem safe. But it's in school. This isn't supposed to happen. And the DA says it's difficult to prosecute. The family wanted to prosecute. They didn't. So this is another case, right, where the girl was willing to take the stand, but they were talked out of it, and they gave them just suspended sentences. But wait, that's not all. An 18-year-old man was sentenced Thursday, so this is 2 years later. This is our prince over here. This is the second article. So after getting away with this assault of a 15-year-old in middle of the day at school, 2 years goes by and he is sentenced. So he's sentenced to 8.5 years in prison for sexually assaulting a 15-year-old girl on New Year's Day in 2013. So it was actually April. So it was really just 9 months later it took him to commit another sexual assault. 9 months. 9 months later, he gets arrested. Can you make it up? No. Would you believe it if I told you it? Probably not. I mean, how could it possibly be? This happens 3 boys on 1 girl in the boys' bathroom at 2 p.m. in the afternoon. She claims it's assault. The DA won't prosecute. They give probation, and 6 months later, the same person who's considered the ringleader does it again. But this time, they give him a sentence. He's sentenced to 8.5 years in prison because he was on probation. He was ordered to serve 10 years of special parole. He pleaded guilty to first-degree sexual assault and admitted to violating probation. He was also ordered to serve 10 years of special parole. He must register as a sex offender. State prosecutor, the same state prosecutor. Oh, how did she feel about that? Vicky comes back and says, well, he was given an opportunity to turn his life around after his first conviction, but he chose to victimize a 15-year-old girl who had known for years. He is his own worst enemy. Yes, Vicky. And, you know, I think you are the schools and the children's and your districts, your county's worst enemy. She said, adding that the most recent incident is worse than the previous one. I mean, we don't have the details on it, but if it's worse than 3 guys assaulting a girl in the boys' bathroom in the middle of the school day, then I don't want to know what it is. Harper's attorney Patrick said letters from supporters and a letter from the victim described the client as kind. Wait, a letter from the victim. Wow. Okay. Describes his client as a kind and caring young man with the right structure and guidance. Harper can become a productive member of society. Harper pleaded guilty to first-degree unlawful restraint incident, which he admitted to having. Okay, with the. I wonder if it was the same. I don't know. He was sentenced that October to 3 years. Okay, so this is the same person that we just heard the whole story and all the incidents and all the and there's this little gnat that has been flying around my room all day, and I cannot find a way to make it go away. It's a gnat, one gnat, and it's for hours. Just anyways, it just seems like, again, so he's going to be, you know, like, if the parole board agrees to it. If they don't, I'll pin the comments. But it's not something that, you know, it's, you know, they basically discuss it for a few minutes, and chances are they're going to agree with the sentence. If they don't, I'll pin it to this comment section of any changes. But, you know, it's like another year, another special parole, and you just have to hope, because it's like these things tend to escalate. But thank you, Richard, for the information. And with that, I'll let you go.